Welcome to Mastering Your Financial Life, hosted by Judy Heft, the founder and CEO of Judy Heft and Associates, Financial and Lifestyle Concierge. This year, she's celebrating 27 years in business. In every episode, Judy interviews professionals who help others successfully manage their financial lives. You can find this show on YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Judy is the author of 2 books, How to Be Smart, Successful, and Organized with Your Money for a Better Today and Tomorrow, and her latest book, Mastering Your Financial Life Cycles, How to Successfully Manage Money in Every Decade of Life. You can read chapters of her books and catch prior episodes of the show at www.judithheft.com. Now, here's the host of Mastering Your Financial Life, Judy Heft.
Welcome, everybody. Hello. Welcome to episode 82 of Mastering Your Financial Life. I am Judy Heft. Excuse me. I have a little frog in my throat today. I apologize for that. I don't know what the problem is. But anyway, welcome to episode 82 of Mastering Your Financial Life. I'm Judy Heft, Financial and Lifestyle Concierge. And today I'm really excited to be here with my friend Gabrielle. Gabrielle Lese is a trust and estates attorney. She's with Anderson Kill, and she really concentrates on estate planning, probate administration. She has particular experience assisting families with blended families with complex estates, and she also works with clients that have disabled families or challenged families to help them set up trusts or whatever else they need. So thank you, Gabrielle. Really excited to have you here today. Welcome.
Well, thank you, Judy. Thanks for having me, and congratulations on 82 episodes.
Thank you. It's my pleasure. So, I think when I talk to a lot of people that come into my office and we talk about different things, and one of the questions is, do I need an estate plan? I don't really have an estate. What does that mean? So maybe you can just, enlighten us. What is an estate plan and who needs it?
I love it. Yeah, this is a perfect question. It sounds like when you say estate plan, you have to be a titan of industry to need an estate plan. You're just an individual. Why do I need an estate plan? So I think the best way to think about it is an estate plan is really a roadmap that you put in place during your life to let your loved ones know what your instructions are if something happens to you. And, simple enough, right? And it's basically, it can be very complex, but at its most basic, I would say an estate plan is 3 documents: a will that deals with distributing your assets, and guardianship of minor children, a healthcare proxy that names an agent to make healthcare decisions for you if you can't make them yourself, and a power of attorney, which is also a lifetime document, which names an agent to make non-healthcare decisions for you or transactions for you. Going back to the will, what that covers. So I mentioned it's asset distribution. I want my assets to go to my spouse and then my children, for example. But it's important when I speak to people about their estate plan, it's larger than the will because your assets also pass in other ways. So for example, say you're married and you own your home jointly with your spouse. On your death, your house won't pass through your will. It goes by law to your surviving spouse if you own it by the entirety together. And similarly, beneficiary designated assets. So IRAs, life insurance, at your death, those transfer by the beneficiary designation, not through your will. So that's why the umbrella term estate plan really covers a lot, not only the will, which deals with decisions made for you at death, but also lifetime documents, the power of attorney, healthcare proxy, and also beneficiary designations.
So what about beneficiary designations that you have, for instance, from your IRA, or even some people have the transfer on death, TOD, for their bank accounts? How does that all factor into your estate plan or your will?
Yeah, so as for me, the first thing I do when a client comes in looking for an estate plan is I get an asset chart, and it's just line items of how they hold their assets. Many people have a substantial brokerage account. Some people have the bulk of their assets in an IRA, and those assets are capable of having a beneficiary designation on them. At death, those assets get transferred, as I said before, by beneficiary designation a lot faster than the will. So the will distributions. Taking a step back, When you have a will, you have to have it probated, authenticated at death. So your loved ones have to take the one original will to the surrogate's court, and the surrogate's court does a review, making sure it was executed properly, and then after the review, issues a certificate appointing executor. So that process is called probate. And I'll talk about this later, if we talk about more complex plans with trusts, for example. But beneficiary designated assets avoid probate. So it's actually a very good planning tool. And it's a very important thing to focus on when you're talking about your estate plan, to know, hey, I've got this major asset and I could leave a beneficiary on it rather than have it go by my will through probate. If that is part of your plan. If you prefer, you might want to leave it to your estate where it gets distributed through your will. But it's an important aspect that can save it. When you focus on it, it's a really important technique for executing your entire plan.
So, I know that there have been people that I've spoken to that have young children and they can't decide, who do I leave, to my children, who should be the guardian. So what happens if they don't have a will? I always say, if they tell me that, I said, well, pick someone now. You can always change it, but you need to have something. You don't want your children to be a ward of the state. But What happens if someone dies without a will?
Yeah, so I get asked this a lot, and I would say right out there, it's not terrible. Basically the saying goes, if you don't have a plan, the state has a plan for you. So if you die without a will, that's called intestate. There's a statute in New York law called intestacy, and the distribution of your assets that you have on your death are distributed according to a family tree. But as you know, and as I know, family trees can be pretty complex these days, right? So that's the downside. So the family tree is basically, under intestacy, is everything to your spouse if you have a spouse, to your spouse and children if you have a spouse and children. If no spouse and children, then to your parents or their children, meaning your siblings and nieces and nephews. Sounds great, right? And it is okay if that's what your plan is, but dire consequences if that's not what your lifestyle is. So say, for example, you're on a second marriage and you don't have a will. And on your death, your assets go by intestacy, approximately 50% to your current spouse and the other 50% shared to your children of your first marriage, let's say. Is that the way you want it? Maybe. Is it not? Maybe, but you're stuck with it and you didn't put your instructions down and your loved ones don't know if this was by default or because you just didn't get to it. So that's one example. Another example, which could have dire consequences if you don't have a will in place for assets, is say you have a live-in partner and you're living in your home that you own and you want to take care of this partner, but you haven't done a will and you haven't made the partner beneficiary. On your death, the partner doesn't get anything under the law because you're not married. So that speaks to the asset distribution if you die without a will. Logistically, how does it play out? Basically, if you don't have a will and you haven't appointed somebody, executor, that's the name of the person following this roadmap of the instructions in your will, someone will step up to the court and say, okay, there's no will, so we're not doing a probate, we're doing an administration. And since there's no will and nobody appointed, I will step up and do this work, be the fiduciary, the representative of the estate, and I will distribute according to intestacy. One downside, a couple of downsides to that. One is that, say there are young people who are getting assets, like say you have minor children or, before we even get to guardianship, talking about assets to minor children. If young children get a share of your estate, a guardian has to be appointed by the court to manage that money. And then you have to create a guardianship account monitored by the court. So every distribution you make for the child's benefit has to be approved by the court. That's not ideal, right? You would rather have named somebody to manage assets for the kids. And when it comes to guardianship, there would be a guardianship proceeding in surrogate's court. Someone would step up and again say, okay, there was no one named, but I'm the uncle and I'd like to be guardian. But it's a more cumbersome process than if you had a will naming the uncle as nominated guardian. You would have a much easier time getting appointed by the court.
And then what if you don't even like that uncle or brother or brother-in-law, whoever it is? Then your kids hated them for some reason. There was something weird going on there. And then, your kids are stuck with this person. So yes, it's so prudent. It's so important for the welfare of your family to create
Yeah.
these documents.
And those are interesting conversations. They can be funny, they could be fun, but better while you're alive and well thinking it through than leaving it
Absolutely.
to chance and uncertainty.
Yes, especially with younger couples that might have young children and they think they don't need anything yet because they haven't accumulated. But you never know what's going to happen. Someone could get hit by a car, and God forbid, and something like that. And it would go quickly, and there's no time left to plan. Yeah. So it's really important to put these plans in place. Yeah, I always believe that. And so, what about trusts? What are some of the trusts that people need?
So right, we mentioned this before. So trust. There are so many different types of trust. And I just want to start out by saying a trust is a fiduciary arrangement. So you're basically saying to someone, here, hold this for me and distribute it according to the terms I set out in this trust agreement. So that's what it is at its heart, the fiduciary arrangement.
It's a great explanation, Gabrielle. I love that. It's just so simple and it makes sense.
Yeah, well, I heard an even better one if you like that. Somebody once described a trust to me as the box of coffee at Dunkin' Donuts. The trust is the box of coffee, and the trustee is the one who controls the spigot.
I love it.
So, yeah, these are nice visuals. So basically, when I'm dealing with a client who comes in for a basic estate plan, the way a trust generally comes up as a start is a revocable trust. So two types of trust as a kind of two categories: revocable, meaning changeable, and irrevocable, meaning unchangeable. Revocable trusts are a common planning technique for people who want to avoid probate, as we were talking about before. That court review, that can take a few months. In some counties in New York, it's taking over 6 months to a year, and that can be crippling as a delay for a family who needs to sell a house, for example, and kind of move on. So for some people, when they want to avoid the probate process, they create a revocable trust, and they move their assets to be owned in the name of the trust, and they name a successor trustee. So as a start, the planner is the trustee, and then if they are incapacitated or on their death, a successor steps in. And then the beauty of that is there's no probate for the assets in the revocable trust. Important to note, there are no credit protection aspects to a revocable trust. There's no estate tax considerations, because technically it's still yours because you can revoke it. It's still owned by you as trustee of your revocable trust. So very different from an irrevocable trust, where people will divest themselves of assets and put it in a trust saying, I can't touch it anymore. And those are mainly seen for Medicaid planning, where you need to be under an eligibility standard. So you say, look, I don't have control of these assets. My trustee has them. They're not mine. Or also it's common for credit protection. If you say, I'm giving this asset away and I don't have it, creditors can't come to me, which is a nuanced field in itself, and depends state to state if you could do that. But basically just the point that it's not yours. It's managed by the trustee.
Yeah, that's pretty interesting. So I had a client one time that had their children. One child was married and the other one was legally separated, not divorced. And they were advised to set up, to set up a trust for that child that's legally separated but not divorced, so that if things change in time and her ex-husband decides, you know what, I want that money, I'm entitled to it, we're still married, he can't touch it.
Yeah. Right? Yeah, so absolutely right. So that's another type of trust which would appear in the will, is called a minority trust. Doesn't only have to be for minors, it can be for other beneficiaries. But basically it says, on my death, everything to my children, but I want this trustee to hold it for the children until age whatever. And what are the benefits of that? Creditor protection for the child, because it's an irrevocable trust as to the child. In terms of divorce, say the child is married at the time and then gets divorced 5 years later, if that money is being held in a trust, it's less likely to have been commingled and termed a marital asset. So generally inheritance is not a marital asset, but once you get it outright and then you commingle with your spouse, it's a lot harder to roll that back. And then the other reason for trust for younger people is, say your child's 25, protection from friends who say, oh, I hear you just came into a lot of money. This way the child can say, well, it's not really mine. My uncle's managing it for me. And just protection from irresponsible decisions. I don't know what some people would do with a windfall of money at 25, but I'm sure I wouldn't have done anything very wise at the time. So it's a bit of a protective element. And that goes back to the point of doing a trust or a will in the first place. You can't put those instructions in if you don't have your will in place, right? You have to memorialize these decisions.
This is really helpful. So let's take a little break right now, and then let's come back and talk some more. I think you demystified trusts for us and wills, and they're so important. And also the word estate, people think, you know what, I don't have this big estate. It's just me and my husband and a couple of kids. We barely own anything. So it's really important to know that estate doesn't really have to mean gobs and gobs of money. So let's take a little break right now and come back.
Hey there. I just want to tell you a little bit about my new book that just came out called Mastering Your Financial Life Cycles. And here it is. It's how to successfully manage your money in every decade of life. I co-authored this with my CFO, Liz Levy. And together we created this manual that's going to help you through every stage of life. We talk about having a baby. We talk about young adulthood, pre-retirement, what to do when you're at that age of retirement. If you're contemplating divorce, do you need an estate plan? We cover all of these, each subject in a different chapter. And I really think that you're going to find this so helpful because at the end of every chapter, we have checklists that you can look at and you can use, and they can be a guide for you. So this is a wonderful manual that we've created. It's available on Amazon. You can also find it on our website at judithheft.com/book. And we're here for you. If you need anything, reach out. I hope you enjoy the book. Here's another picture of it, just so you know what's going on. Here it is. And I'm really proud of it. It's my second book. And I'd love to have you read it and give me your feedback. Judy Heft, judithheft.com, financial and lifestyle concierge, celebrating 26 years in business. And over the years, I've learned so much. And what I've been trying to do is impart a little bit of this knowledge to you so I can help all of you become as financially organized as I am.
Welcome back. We're here with Gabrielle Lese. I'm really excited to be with her, trust and estates attorney. And we're talking about wills and trusts and why they're so important. So for instance, so I know that, there's that limitation. You can gift every year to your children or to whoever you want, actually. And, if you're a couple, you can, what is the limit, up to 15 now? Or
it's 18 this year, 18,000 per individual.
18,000 this year. Okay. So that's really good to know. And, should that money be in a trust? And if you're doing that every year, does it end after you pass away, or can that be part of your trust? I don't know.
Well, that's a good question. That is a lifetime annual gifting exclusion. So it ends on your death, your capacity to continue giving annual gifting. That's a really good question as to whether it should be in trust for the beneficiary, the person you're giving it to. And the answer is it depends. If they have a massive estate and they're worried about accumulating more money for estate tax purposes, where they might be over the threshold, and this is a world unto itself, the world of estate tax. Fortunately, many of us don't have to worry about it right now because the federal estate tax exemption is $13.61 million, and the New York State estate tax exemption is almost $7 million. So if you're under that, you don't have to worry. But say you are in that field and you think I may go over the exemption, and say your child is accumulating a lot of assets and you don't really want them to be accumulating anymore, but you still want to spend down your own estate and make use of this gifting, you could set up a trust for them and pay these annual gifts into an irrevocable trust for the benefit of the child. As with everything, it's very case specific. It depends, but it would be a good technique to both spend down your estate and build up a savings for the beneficiary, and benefit from kind of freezing the appreciation on the amount that you're gifting to the trust.
So why would someone want to create a revocable trust as opposed to an irrevocable trust?
Yeah, so revocable trust is purely a decision for, I'll tell you the drivers for it. Number one is avoiding probate, as I mentioned before. So things that are owned by the trust pass through the contract of the trust agreement, not probate. Number two is incapacity. So say you become really incapacitated, your successor trustee can step in and manage your assets. Number three is it's private. A will is a public document. So if you have a regular will and it's probated, to some people that's an issue. That's why when a celebrity dies, a couple of weeks later, you see in the New York Post, this and that person left this much money to his son. And, a lot of people don't want that in the paper, or findable by an ex-spouse or something like that. There are a lot of reasons people want to keep it private.
Or they left it to their cat, something. They wanted Leona Helmsley leave everything to.
Right, exactly. Exactly. So the easy way to get the privacy is to create a revocable trust.
Oh, that's good to know.
Drivers. And I'll give you one other reason for a revocable trust is, say you own a house in another place, like say you own a place in Vermont. If you had a will plan, you would be doing probate in New York and in Vermont. But if you created a revocable trust, you could title the Vermont property into the revocable trust as well, and you would avoid the two probates. So it's, again, case specific, but for people who, for whom any of these drivers resonate, it's a very good planning technique.
There's so many interesting things that you need to know about, planning a will and estate. I think we really helped a lot of people here today, demystifying. So what are some of the things that you wish every person knew about estate planning that we didn't talk about today?
Oh, I love it. I love it. And I love talking about this. I could talk about it all day long.
I can hear your passion, Gabrielle.
Yeah, it's a great field. And for this reason, which answers your question, despite the fact that you are contemplating your mortality, and that's hard for a lot of people to talk about. In actuality, you're talking about the people you love, and you're getting ahead of it during your life and saying, this is what I want to happen, and this is who I want to take care of. And I would say, by and large, the people who come in to work with me on their plan, they say, I want to make things smooth for my children when I pass away. I want to leave things in good order. That's the motivation. So because of that, it's very collaborative. It's very positive, even when there are tricky issues like the second marriage. And, it's hard to face those things. So not only mortality, but you're talking about, okay, how do I honor my second spouse, but protect my children? But to me, you're still talking about who you care about. And number two, the clarity is the key to enacting that desire of making things smooth and clear and kind of followable for your heirs, rather than leaving uncertainty and a grab bag of tasks. So that's what I would say. I would say generally people should enjoy the process of getting their house in order and knowing that they have created a roadmap for their loved ones.
That's a great message to end on, Gabrielle. Thank you so much. This was great. And how can our listeners find you?
Oh, thanks. Well, I am at Anderson Kill. You can reach me at glese@andersonkill.com. And I'd love to hear from anybody who wants to have a chat. And I'm very happy to have preliminary conversations. If somebody, it's a big decision, and I'm very happy to have this preliminary call to go over first thoughts, kind of introduce myself, explain the process.
That's great to know. And do you charge hourly for an estate plan, or is it a fixed flat fee?
By and large, flat fee. Clients tend to prefer flat fee. I will do hourly when there's a lot of uncertainty as to which direction we're going. But if we have that preliminary call and I say, okay, I know what this world is going to look like, by the end of the preliminary call, I give a ballpark, and by the end of the estate planning meeting, I know what I'm doing, and then the flat fee will be somewhere within that ballpark, depending on the complexity of the plan.
Well, that's great to know. Thank you so much, Gabrielle.
Yeah, thank you for having me, Judy.
My pleasure.
Thank you for tuning into Mastering Your Financial Life, hosted by Judy Heft. You can read chapters of her books and catch prior episodes of the show at www.judithheft.com. Thank you for your positive comments and sharing this show with others.